Hi and welcome, welcome to my channel. So today we are going to look at civil litigation summary, and the book will refer to is the Kenyan Advocates Training Program 9-in-1 ATP Summary, second edition of 2021. Now, from the first look of this book, I can see that civil litigation is the one that is the biggest out of all of this. It's the biggest chunk. Okay, it's chapter 1. So we'll try and cover roughly just so we know what's going on. Okay, I don't think we can be able to finish the whole thing, but we can try at least to reach as far as we can. So civil procedure. Okay, we have this whole map that outlines the phases, the phase of before trial and during trial, and then post judgment. Post judgment phase, where the parties try to get to extract the decree. Let's take our sweet time here. So we have the first thing here, that is under pre-litigation phase, that is pre-trial, is a dispute. So there is existence of a dispute between parties, and then the parties opt to can either the parties have three ways of resolving this dispute. They can deal with the dispute through alternative dispute resolution mechanisms, and this is where I remember there's like a committee that checks everything, every case before it qualifies for trial, to see if it can be handled via via other dispute resolution mechanisms like mediation and arbitration. So the second option the parties have who are faced with a dispute is to solve the dispute through litigation, that is through trial in a court of law. And the other option is to resolve the dispute between themselves. Pre-trial stage is to issue a demand letter and notice to sue. Okay, so the party that is aggrieved will issue a demand letter to the defendant to be, and this demand letter, of course, we know the contents of a demand letter are very straightforward. It simply relates to the demands, as the name suggests, of the aggrieved party. If it is payment, it indicates the sum to be paid. Okay, the sum to be paid up, failure to which there will be consequences, of course, and the consequence is of course to be sued. Okay, to have the matter taken forward, as well as it will indicate the timeline for payment of that demand that you are seeking. So this will be followed, of course, by the reply to the demand, where the defendant to be or the other party now either agrees to pay up or denies having any uh, any debts, okay, or having done anything wrong or having breached any contract. They will deny or accept. If they accept, this is the end. Of course, after they pay up, you don't need to sue them because you have your matter addressed. If they don't, in that case, then the matter proceeds to go to trial. You proceed to sue them. So now yeah, so that's all about the pre-trial phase. Then that is followed by trial phase. Now this is where, if parties proceed to sue, what happens is there is presentation of pleadings to the registry. So the party that is suing in case of breach of contract will have their representation or advocate draft a plaint, and a plaint we already know how that looks like. We have description of the parties, the plaintiff and defendant, address of service, then that is followed by the cause of action. In this case would be breach of contract, failure to pay or something. So every matter that you want to be pleaded, you should plead specifically so that you don't surprise the other party in the course of trial. So all these rules that are related to plaints under the civil procedure rules, that is what you will look at. You will look at those. So that means you have to indicate particulars of the cause of action. Where you are pleading breach of contract, you explain. Where you are pleading negligence, you explain. Where you are pleading all those things, you explain. Then you are going to also follow that with prayers that you wish the court to grant you as a plaintiff. And the plaint is accompanied by the list of documents, meaning anything that would be qualified as evidence to be admissible, that will strengthen your case or provide evidence as to your claim, or that would include in the case, maybe the contract, the agreement that you had would be annexed in the list of documents. You can have the demand letter. I don't know if you could annex the demand letter, but I believe the party uh, who issued the demand letter can have benefits as to costs of the trial. They can demand costs of the trial. So what happens is that you have your list of witnesses, those you are going to who are going to testify on your behalf. You can have what else accompanies, or you are verifying affidavit that verifies the contents of the plaint. Okay. That will be followed by once you file this plaint at the registry, you are going to verify and assess them. That is the next process, followed by payment of court fees and registration of pleadings, and then issuance of summons. Then summons is served to the other party. The other party Okay, summons is served to the other party, followed by filing of affidavit within 14 days of the service of summons to the defendant, and then that is followed by the defendant enters appearance, in which case he will file. He will he will he will enter appearance through filing a memorandum of appearance, and then followed by filing his statement of defense or counterclaim if he has a claim against the plaintiff as well. And where he proceeds to file a defense, where the defendant files a defense, the plaintiff can reply to the defense or counterclaim, and it is advisable for the plaintiff to reply, because if there are new matters raised in the defense, those matters, if you don't reply to them, they'll be taken as admission. Okay, it will be counted as admission. So it's important to reply. That is advisable. So then the plaintiff files a case management checklist, that is the pre-trial questionnaire, and then followed by serving the case management checklist to the defendant, and then that is proceeded or followed by a case management conference. And the purpose of this case management conference is to see in which manner the trial will take place, assess the witnesses, assess the issues that are in dispute, okay, and the court, that will be followed by the court that completes the case management checklist and gives a case conference order. Then that will be the trial will, or the hearing will start from there, and then judgment is given on the merit of the case by the judge or the court. Okay, that is if the defendant were to file a defense. What happens when the defendant is a no-show, or they don't file the defense, they don't enter appearance? There'll be an interlocutory judgment. Okay, okay, if they don't enter appearance, the plaintiff can ask for summary judgment. Is it summary judgment or interlocutory judgment? I don't know. Perhaps there's a difference between these two. Of course, I'm sure there is. Why else would they call them differently? I know summary judgment you can request is where the defendant fails to file a defense, in which case the plaintiff can request for a summary judgment or a judgment to be entered, okay? And then the defendant becomes a judgment debtor. I don't know, let me just check. I confused this. Okay, I can see it here. Let me just use this book. Okay. Yeah, so a summary judgment is applicable when there is a specified amount or a demand that you can liquefy. For example, where in the cause of action for breach of contract, the defendant prays for the payment or the refund of the monies he paid to the defendant for sale of goods, which didn't go through. So maybe let's say he paid 700,000 shillings. So he asks for that return, the refund of the amount he had paid plus interest, amounting, let's say, to 20,000 shillings. So 720,000 shillings would be payable. So it's liquidated. So this is a claim for it. This happens normally in summary judgment in cases of claims for recovery of land. Okay, if a defendant does not file a defense, the plaintiff can request a summary judgment. That is Order 10, Rule 4. The Order 10, Rule 4 of the civil procedure of the civil. Order 10, Rule 4 of the civil procedure, rules Form 13. So that is request for judgment. We have the title, the High Court, the plaintiff and the defendant. Request for judgment, Order 10, Rule 4, Civil Procedure. The plaintiff requests for judgment against the defendant who has failed to appear, okay? The request is for interlocutory judgment for Kenyan shillings 7,020,000 shillings, okay, and cost. Dated at Nairobi this day of April by so-and-so advocates, okay? So another key thing you need to note is when it comes to summary judgment, you cannot apply for summary judgment against the government, but the government can do so against you, okay? The defendant can request leave to defend suit. So where the plaintiff requests for a summary judgment due to lack of appearance by the defendant is allowed to request leave to defend suit. The defendant does so by way of an affidavit, okay? Court can enter partial judgment. So the court can also enter partial judgment, can grant some prayers, judgment, on the face of it, and set up for hearing other substantive issues, okay? So the defendant files an affidavit in response to the request for summary judgment. So that is about summary judgment. moving on, the post-judgment phase. This phase is about there being no appeal if the plaintiff does not if the defendant does not appeal against the judgment, there'll be an extraction of decree. Okay, this is a process called extraction of decree, which will lead to execution of decree. Okay, and then where the defendant appeals, okay, there'll be an appeal that will, of course, judgment will be altered or reversed, or in other case, which judgment will be upheld and appeal will be dismissed. So that is like the whole map of civil procedure in three phases: the pre-trial, the trial, and the post-judgment phase, which is very interesting, especially the post-judgment phase, because I'm not very familiar with this, and I hope and I pray that we'll be able to look at this phase, okay, today in detail. Yeah, I'm gonna post a separate video about extraction of decree. I think I may have this book here by Manuel Kubica that explains it. I'm sure there is some kind of post-judgment topic here we can look at in depth. Jurisdiction, institutional. Yeah, so it's chapter 15 in the book, Civil Procedure, Concept of Civil Procedure in Kenya by Emmanuel Kubika. So we are going to have another whole, let me just mark this. We are going to have a whole video that will talk about the post-judgment phase, where we explain, okay, we explain how this is all about, how this works, execution of decrees, and yeah, and costs. We are going to look at costs as well. All right, so that's it. Let's move on now. Now, of course, the following is the court system in Kenya. We know what this is all about. I've gone through this. It's not gonna suddenly change. Okay, we have the Supreme Court, followed by Court of Appeal. Okay, that is followed by the High Court of Kenya, which has original jurisdiction, unlimited, to hear both civil and criminal matters to do with infringement of Bill of Rights, okay, or freedoms. Okay, so that is the High Court. Then we have the special tribunals or courts. We have the business premises, okay, rent tribunal. We have the, wow, all these are very important. And now I'm seeing that. So let's just look. Yeah, so the special courts and tribunals, we have the Employment and Labor Relations Court, okay. We have the what do we call it, the Environment and Land Court. We have the Business Premises Rent Tribunal. We also have the Rent Restriction Tribunal. Yeah, I think those are the ones. So those are the special tribunals or specialized courts. Then that is followed by what do you call it? The subordinate courts, which we know. Um, Subordinate courts of first class include the resident magistrate court, the district magistrate court of first class, the principal magistrate, the senior principal magistrate, senior resident magistrate, chief magistrate, and I don't know what else. So we move on. Introduction to civil litigation. Only a small subset of dispute proceeds to lawsuit. We know that, so others can be resolved. Can be resolved by ADR. Okay. Now, in the Kenyan legal system, application of judicial precedent stare decisis to civil precedent can. So, what happens if parties opt for trial or litigation? What rules guide the courts in helping or arriving at decisions and arriving at justice? Okay, we have the doctrine of of judicial precedent. That is where we have evolving jurisprudence on a matter and the courts decide on a matter. Okay, they could decide one thing uh, 10 years ago, but due to evolving of the jurisprudence or precedent, the matter could be could be upgraded, and a different decision can be made on the same set of material facts that were once used 10 years ago and given a different verdict. So the rule that applies to courts under the judicial precedent is that the courts are bound to follow the decisions. It is preferable to stick to decisions and not to upset matters that have been settled. So this is the position in the case of Martin Nyaga Wambora, where the court noted that common law theory has been used in Kenya because of the country's common law tradition. Okay, so all right. So that is also in the case of Dothia versus National Bank Limited and another. The legal system needs a high level of clarity and consistency. So the reason why the courts are guided by this judicial precedent theory or concept is because of clarity, consistency, of stability, of rule of law, of jurisprudence, I would say, to maintain a status of consistency in the judgments that are provided to us to the same set of facts. Okay, it also promotes or boosts certainty. So that is what is stare decisis. Now moving to another rule, the vertical precedent or horizontal precedent. Um, a court should uphold a judgment of a judge of equal authority unless it seems to be obviously incorrect. So this vertical and horizontal, vertical is where courts of higher hierarchy which decide matters, and those of lower hierarchy follow the decisions or the set of judgment, uh, how to make that judgment given the same set of facts. Okay. So these decisions of higher courts, they have a binding, they bind the decisions. Okay, they bind the lower courts. So moving on. Is the Supreme Court bound by its decisions? Or in the case of Justice Singh and others, it was whether or not the Supreme Court will adhere to its precedent or depart and make another judgment. Okay, the court determined that the answer to the question is okay. Question problems. It can indeed depart from its previous decision for good cause and after taking into account legal considerations of significant weight. So yes, the Supreme Court can depart from its own decision made previously on the same set of facts for good cause. Okay, whether tribunals or specialized courts are bound by their own decisions. We see in the case of Kenya, SGS, Kenya Limited and versus Energy Regulatory Commission. The petitioner, okay. So, where is the holding? Okay, so in a nutshell, the court found that on the basis of the above considerations, the specialized tribunal should be able to identify important merit elements in each important merit element, be able to use appropriate abilities, and be free to prescribe remedies based on the facts of each case. So it's a case-by-case basis. So the tribunals are not bound by stare decisis, okay? So whether the High Court can depart from a decision of the Court of Appeal, whether the High Court can depart, yeah, interestingly. So the High Court can depart from a decision of the Court of Appeal if there's a strong reason to do so. A strong reason to the contrary does not mean a strong argumentative reason appealing to the particular judge, but something that may indicate that the prior decision was given without consideration of a statute or some authority that ought to have been followed. Yeah. Okay. So where there's any defects in the previous judgment given due to having not followed a statute or authority that ought to have been followed, then the subsequent judgment can depart from the previous judgment. Okay. Now, what is the law governing civil procedure in Kenya? We have the Civil Procedure Act, the Civil Procedure Rules. Yeah, these are things we know about. We have those that prescribe the structure of the courts, being the Magistrate Courts Act. Okay. What else? I don't think there's anything else here. Okay, so what is the scope of application for the civil procedure rules? The civil procedure rules don't apply to non-contentious or common form probate proceedings, and what applies in its place is civil probate and administration rules of 1980. Okay, so the rules apply in non-contentious probate proceedings. Okay, insolvency proceedings. The Insolvency Act, number 18 of 2015, gives the courts the power to make insolvency procedure rules, gives the act the power to make insolvency procedure rules. So the rules committee with the official receiver make rules providing for the procedure of the court under insolvency, the appeals to the Court of Appeal from decisions of the court in insolvency matters. So matters that may be dealt with by the rules include how proceedings may be commenced, where proceedings may be commenced, the forms to be used in proceedings, the service or issue of documents, the amendment of defects and errors, how evidence may be given in proceedings, how the identity of persons who are parties to or involved in proceedings can be proved, how witnesses can be summoned, and documents served, the right of creditors and other persons to appear in proceedings, the notices required to be given in connection with proceedings, and who may give them, the manner of advertising proceedings, the consolidation of proceedings, the substitution of parties, authorizing the continuation of proceedings after the death of a debtor who is a party to proceedings, authorizing proceedings to be begun against one or more partners of a business partnership without including the others, the scale of costs of advocates and others in proceedings, the award of costs, and when security for costs has to be given, the execution of processes, and the enforcement of orders. Okay, and the deadline for appealing to Court of Appeal. Okay, and how the appeal may be brought. So we see that in insolvency, it's a whole different universe, and the Insolvency Act, the insolvency rules. Okay, if there are, so let me just check insolvency rules, Insolvency Act, insolvency rules, insolvency. Uh, mm, so insolvency procedure for application of license to act as, so we have insolvency regulations of 2016. Those are the ones that provide for this whole business of proceedings in insolvency. Moving on, matrimonial proceedings, the matrimonial proceeding rules, okay, of 2020, sorry. These rules were enacted in exercise of the powers conferred by Section 95 of the Marriage Act 2014, empowering the Rules Committee to make rules regulating court practice or procedure under the Marriage Act. Okay, the rules provide for commencement of matrimonial proceedings, service of petition and other court process, answer to petition, cross petition, and interlocutory decision proceedings, certificate of compliance, hearing, and decrees. All right, so that's it about that. Now, there's a step-by-step process. We already said this. Yeah, we already said this step-by-step process of civil procedure in Kenya. We already said this. No, 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 no. Let me just go through it again, just so we know moving forward what we need to do. Okay, interesting. Okay, now moving on, we have processes of civil procedure in Kenya. Of course, the first is demand and notice to sue. The plaintiff writes a demand letter to the defendant, and then we have the reply to demand, where he admits or negates, okay, or denies. In which case, if he denies, we move forward to file, serve, and to file and serve our pleadings. So, filing of the suit where the defendant fails to pay up, the plaintiff proceeds to file suit. They'll check the appropriate court to file the suit. So that is very important, because some suits can't be heard in some courts because of jurisdiction. So you will look at the jurisdiction of the court. The jurisdiction is either pecuniary when it comes to money wise, where the Chief Magistrate Court has jurisdiction to hear matters pertaining to, has the pecuniary jurisdiction of, I think, was it 7 million shillings, if I am not wrong. Let me just check this. Yeah, so jurisdiction. So here we have the Chief Magistrate's Court at 7 million and below, the SPM at 5 million and below, the principal magistrate's court, the senior resident, this principal magistrate's court is at 4 million, senior resident 3 million, resident magistrate 2 million, district magistrate court 5,000 to 10,000, of class 1 5,000. Okay, interesting. The jurisdiction of the Supreme Court, the Court of Appeal and High Court is unlimited. Okay, it can go to billions of shillings. Then we have what we call concurrent jurisdiction, where different courts can exercise the same jurisdiction. Okay. So that is what we need to know. Most of the times you'll find suits filed at the Chief Magistrate's Court of 7 million and below. Okay. Yeah. That is followed by the Senior Principal Magistrate's Court, which is 5 million and below. So that is what normally happens, okay, which is interesting. It's very interesting for me because, sometimes you might just overlook and say, oh no, but this is not something that you can overlook. Okay, so you could file your case in the wrong court and have it dismissed, okay, for lack of jurisdiction. So it's very important. Now, appropriate court depends on the nature of the case and the amount. We already said. Present the plaintiff at the court registry. So once you know which court you are going to, let's say the Chief Magistrate's Court, 7 million, and the subject matter of the suit is valued at 7 million. We can go there. So present the plaintiff. You present the plaintiff at the registry of the Chief Magistrate's Court with your accompanying documents, the list of witnesses, list of documents, the verifying affidavit, witness statement, and payment for its filing, okay? So this payment will be arrived at after assessment assessment has been done, okay? Now, service. The plaintiff, through a qualified process server, is required to serve a copy of the plaint and the summons to all the defendants, and then file an affidavit of service. The defendant is to enter appearance after being served, okay, with a memorandum of appearance, okay? So, and then file his defense, in which case he will also have an opportunity to file a counterclaim if he has a fresh claim against a cross claim against the plaintiff. A set of, there's so many ways he can defend himself. So there are so many ways. Set of counterclaim. We have tender in payment, we have performance, all those defenses. So if he does so, he will file, of course, an affidavit of service after he has served the plaintiff, okay? So the plaintiff then can reply to the counterclaim, okay, or reply to the defense, and where he doesn't reply, which is not really advisable, that will lead to the close of pleadings, okay. So the service B serves D with the reply to counterclaim, okay, that is plaintiff serves defendant. Then close of pleadings, the reply to counterclaim is considered the last document or the reply to defense. However, where there's no reply, the defense is considered as the last document. Pleadings are considered closed, okay, at this point. Then we move to pre-trial procedures where there's the checklist, the case management checklist that is filled in by the plaintiff. It is filed and served, okay, and serve to the defendant. Then that is followed by case conference. The court then convenes a case conference. Case conference are used to identify the issues, to set up the manner in which the proceedings will be done, to help the parties to settle the whole or part of the case, okay? So where some partial judgment can be entered at this point, the court will proceed. So case conference order is issued by the court at the end of the case conference. Then the matter proceeds for hearing. The court sets issues a hearing date, and the plaintiff normally begins first because they have a burden of proof to discharge, okay, as far as their claim is concerned, and then they set their case and present both oral and written evidence, and that is followed by the who is this, yes, by the defendant's case, who also now presents their case once the plaintiff has finished, and calls witnesses and produces both oral and written evidence. Then submission stage comes in, where after they have presented their case, both parties are then allowed to file their final submissions. So the parties file their final submissions, okay? And then judgment is the next stage. The court sets a day for judgment after parties have filed their final submissions, and then the decree is done, is given. Following the reading of the judgment, the registrar draws, seals, and issues a court order or decree. So the registrar here is the one who extracts the decree and draws and seals it and issues a court order, or can issues it. Any of the parties can prepare a draft decree and submit it for the approval of the other parties. The decree ought to clearly specify the award sought and granted. Where the draft decree is approved by the parties, it is submitted to the registrar, who, if satisfied that it is drawn up in accordance with the judgment, signs and seals the decree. So you can see how this whole thing is, okay, and it's very interesting. All right. Okay, so let's just let's start with the question. Let's start with the first step. Okay, the very first step, that is pre-trial, that is starting with our demand letter right here. So we'll start with this just to structure the whole process, okay, because all these notes are like all over the place. So just not to get lost, let's follow the structure or the map we had highlighted before, starting with the pre-trial, followed by the trial, and then the post-judgment. Okay. Now, we know the first step is a demand letter. To issue a demand letter where the plaintiff or the person aggrieved writes a demand letter to the other party, stating out the claim plus the payment and the timeline for payment and the consequences of failure to pay. So we can see the form of a demand letter is very straightforward. It is written directly to the defendant or the defendant's lawyers. The letter is intended to do the following: claim for relief by alerting the other side of what claims lie against them. So there's a claim for relief that is going to be, is going to be asked for, okay? And then it is intended to avoid litigation or trial in the court, okay? So in framing your client's claim, consider being courteous. So there are certain rules of ethics while drafting your your demand letter. It doesn't have to be polite and precise. You must say only the material facts, okay, which which disclose the claim, okay. After the receipt of a reply from the defendant, you are required as the plaintiff's advocates to ponder over the matter and consider whether there are alternative means to settlement other than litigation. So where the defendant is giving a space or a go-ahead for settlement out of court, you are encouraged to go with that, because not every matter should be taken to the courts, okay? There's a reason why we have the filter for the ADR filter for mediation, arbitration, and negotiation, okay? That the courts normally try to qualify whether the matter is contentious enough as to qualify for trial or should just be settled out of court. The contents of a demand letter: authority of the advocate to represent the clients. So the first thing we have, the first sentence is you introduce yourself in the demand letter. So for example, you say, we act for Mr. Juma Kabati, who is a law-abiding citizen and the purchaser of property LR number this and this, okay? Our client okay, brought to our attention that despite her lawful purchase of the said land on this date, you have refused to transfer the title. Okay, so you are acting under the instructions of your client. So it's important the language you use is also reflecting that. Statement of the cause of action. So the other most important thing is the cause of action. It must be clear and precise and short as possible. So what is the client complaining of? That he paid for the purchase of the purchase price of the land, but he has not been granted title. Okay, the defendant has not transferred. Okay. Or in a simple case, we could have that someone has not paid rent amounting to 50,000 shillings for 5 months. Okay, so they would receive this letter saying that it is brought to our attention, or our clients brought to our attention, that you have not paid rent amounting for this amount of uh, for this long, amounting to this uh, Kenyan shillings. Okay, that would be the relief, sorry, that would be the claim, and the relief sought is very clear. Okay, you must state whether you wish for payment. So you say so our instructions are to demand the payment of 50,000 shillings being rent arrears, okay, for the months of, you say, January, February, March, April, May, June, okay, of 2022. That is the relief sought. The timeline is the next for compliance, that it should be reasonable to afford the opportunity for payment. So take notice that if you do not do the aforesaid within 14 days, that is where the timeline comes in. You must be specific with the timing. Upon receipt of this notice, our client will be constrained to take further action by instituting legal proceedings. So we have the timeline and the consequence of default. So where the defendant is not yet a defendant. So where the other party does not comply by paying, they have a consequence that is very clear to them here, that our clients will take further action by instituting legal proceedings on that account at your risk. Okay, at your risk as to cost. So I heard that whoever files a demand letter is awarded costs. Okay, okay, is awarded cost of the trial. So the cost of trial, meaning the cost they incurred while taking the matter to court, because they tried to have an out of court settlement. So they initiated the demand process by trying to avoid the matter to go into court, but then it wasn't successful. So the costs they incurred of the advocates, of filing, they will be given if they filed this. So that is just that. Okay, then you sign off. Gadamfara Company Advocates, PO Box 333-00100, Kimathi Street, Ecobank Towers, 13th floor, Nairobi. And that's it, you are done. So there's a letterhead, there's a template here, there's a letterhead. That is, the letterhead is of course of your company. If your company is well registered and established, you would have your PO box, your office, your email, your address, physical address. Okay, and yeah, that will be your letterhead. Then your our ref. So your reference, you write the your reference, you add, perhaps it's a serial number of the number of demand letter, which number it falls on in that year. Our ref, your ref, I don't know, but that is what happens. Your ref, our ref, and the date of the demand is important because of the timeline that you are going to give. Okay. Yeah, so then you have the address of the person you are sending the demand to. Mr. So-and-so, tell this, email this, dear sir, you have your reference, demand for immediate payment of rent arrears, and then we act for this. Our clients brought to our attention this. So we act is number one. The claim is followed. The short facts of the case: on this day of this, you did not this. Then numerous attempts to have you pay the rent have been futile. You have avoided maybe the calls, you didn't pick the calls, you moved, or you traveled to avoid the harassment. So our instructions, then you say the instructions are to demand. So you can see the whole nature of a demand letter is to demand. Failure to which action or a trial or um, parties go to litigation, you are sued. Okay, so that is the demand, the first stage. Parties to a suit. Now, who can sue? After we've decided we want to sue, who can sue? Okay, then we look at how to approach the court, which types of pleadings we are going to use, amendments, striking out, whether affidavits are pleadings or not. Those are technical matters. Amendment of pleadings, the type of pleadings. We have the plaint, we have the, what do you call it? Yeah, we have one beautiful sample of a plaint. And then we have a reply to a plaint. Okay, very interesting. Notice of motion. Then we have what is this? Yeah, we have all the types of pleadings: originating summons, chamber summons, whether or not they are pleading is discussed. We have the notice of motion. Yeah, and those are the types of pleadings we look at. Okay, so Godspeed. Now, parties to a suit. Now we have decided to sue. Who can sue? That's the question. Any person in whom legal rights vest and that right is infringed or threatened can go to court as a plaintiff. So if a party has suffered infringement of their rights and or they are about to suffer, excuse me, or they're about to be, to suffer certain infringement, they go to court as a plaintiff. A legal right. So a person who has a right and that right was taken away from them, leading to an injury. I don't think injury is a must, but we have that chain. Okay, so a legal right may either be a right based on constitution, can be a constitutional right, fundamental freedom, statute, okay, customary law, and all laws that have applicability in Kenya. A plaintiff must be a natural or juridical person, okay? Okay, interesting. Fort Hall Bakery Supply Company versus Wanguwe. On an objection against the plaintiff's suit was allowed and suit struck out. The group had not registered as a company as required, okay? The government can also sue and be sued. Such suit must be in the name of the Attorney General. So companies that seek to sue must be duly registered. The plaintiff can also sue. The government can also sue and be sued, and where the government is sued, a notice must be given to the Attorney General of 30 days. Yeah. And such suit must be in the name of the Attorney General. So the Attorney General will be the plaintiff where the government sues, and the defendant or the respondent where the government is sued. Suits by representative parties. Where the legal rights of a trust property are infringed, the trustee is the right plaintiff. Okay. So that is what that is. Just a minute. Okay, so moving on. That is the interesting thing. Where was I? Sorry. Now, suits by representative parties. I know this one. So where there are many plaintiffs, okay, they don't all have to appear there. Someone can sue on their behalf if they have been authorized by the parties, and of course the letter of authority must be annexed, okay, as part of the pleadings to show that the parties indeed agreed to let this person be their spokesperson of their representative, okay. So we also have where the legal rights of a trust property are infringed. So where we have the existence of a trust property, the trustee it becomes the plaintiff, where the legal and not the beneficiary. Okay, so where legal rights of the estate of the deceased person are infringed, the right party who represents that case will be the administrator or executor, and the capacity of representative parties must be sufficiently described, okay. So for example, in the heading or in the in the title of the pleading, you would indicate so and so administrator of the estate of deceased as plaintiff, okay. So the capacity must be well written. If it's a trustee, you say so and so trustee, okay, of the trust property, uh, of as the plaintiff. So suits by or against partnerships, order 30 of the CPR. So a sole partner trading in his true name can sue in that name, okay. So where we have a sole proprietorship and the partner and the person works solo, he can sue if he trades in his true name. For example, I'm called Zainab Kadamba, so I'll say if my if my if I'm trading in the same name, if my company is also called Zainab Kadamfar and Company Advocates, I can sue in that name. Where a sole partner is not trading under their true name, for example, I call my law firm the Juice Bar and Company Advocates. Okay, that is far-fetched. Let me say I just call it Res Ipsa Loquitur and Company Advocates. Then in that manner, I I would sue in my true name, okay? Then add trading as. So I would say Res Ipsa Loquitur and Company Advocates trading as. No, sorry, Zainab Gaddafi trading as Res Ipsa Loquitur and Company Advocates, okay? Now we have another case here. So we have the case of Hora versus Hora 1959, where it was held that where there are many people trading under a partnership name, okay, in which case you may not be using your true names, use the name of the partnership as the plaintiff, okay. A foreign firm not carrying on business in Kenya cannot sue in the business name, okay. To sue, they must disclose all their names. So that is applicable when it comes to local companies, but where you have a foreign company, because it's not, of course, registered in Kenya, so you cannot use the business name because it's not considered as a registered entity, okay, in Kenya. What you would have is the name of the partners in their individual capacity. All right, so that is that. Suits by and against persons under disability, Order 32. Minors and persons of unsound mind cannot sue in their own right. So this is Order 32. Order 32, Order 32, Order 32. Now, Order 32 is talking about minors and suits by or against. Okay, that is Order 31. Sorry. Suits by or against minors and persons of unsound mind. That is Order 32. So Order 32, Rule 1, a minor to sue by next friend. So a minor has no capacity to sue, except they can sue by an ex-friend. Every suit by a minor shall be instituted in his name by a person who in such suit shall be called the next friend of the minor. So his name will be there, okay, but there will be a guardian or somebody called the next friend, okay. Before the name of any person shall be used in any action as next friend of any infant, okay. Where the suit is instituted by an advocate, such person shall sign a written authority to the advocate for that purpose, and the authority shall be fined. So this is representative capacity. You must always, when you talk of representative capacity, have an authority letter, okay? An authority that is signed by the person and filed together with the pleadings to show that the person who is suing or being sued is actually, has given their authority. So where suit is instituted without next friend, where a suit is instituted by or on behalf of a minor without an next friend, the defendant may apply to have the suit dismissed with costs to be paid by the advocate or other person by whom it was presented. Notice of such application shall be given to such person, and the court, after hearing his objections, if any, may make such order in the matter as it thinks fit. So where a suit is instituted by a minor, where the advocate proceeds to institute a case using the minor alone without any next friend, the defendant has cause to apply for dismissal of the suit with cause. Guardian ad litem, where the defendant is a minor, the court, on being certified of the fact of his minority, shall appoint a proper person to be guardian ad litem, okay? An order for the appointment of guardian ad litem may be obtained upon application in the name and on behalf of the minor or by the plaintiff. Okay. Okay, such application shall be supported by an affidavit verifying the fact that the proposed guardian has no interest in the matters in controversy in suit adverse to that of the minor, and that he is a fit person. So this application is by notice of motion, I think, if I'm not wrong, supported by an affidavit. Let me just make sure. But really, a notice of motion as an application. Let me just see. Yeah, I don't see it anywhere here, but yeah. Yeah, so it's an application that seems to me, because applications in the civil procedure rules, all applications are by way of, that is order 51 rule 1, by way of a notice of motion. Okay, so I will just go with notice of motion with a supporting affidavit. Let me just write it somewhere. I don't want to forget. I don't want to. It was order 32, right? If I'm not wrong. Order 32. Order 32. Order 32. Order 32. This is an order for the appointment of guardian. An order for the appointment of guardian ad litem by the court for a minor can be made by a notice of motion application plus a supporting affidavit. Okay. All right, so moving on. Let me just read this part because it's important. So where the defendant is a minor, the court, on being satisfied the fact of his minority, shall appoint a proper person. So where the defendant is a minor, is being sued, that is when the court appoints a guardian ad litem. Where the defendant is suing, he will sue with an ex-friend, okay? So let me just write this here so we don't confuse this, okay? So where a minor is the defendant, guardian ad litem. Where minor is suing plaintiff, it will be next friend. So a next friend. Okay, so that is that. We move on. We move on. We move on. We add this next frame. We got it for the shoot. Now, so we know that Okay, who may act as next friend or be appointed as guardian for the suit? This is interesting. Let's see who can do that. Any person who is of sound mind. So sound mind and is an adult may act as next friend of a minor or as his guardian ad litem, provided that the interest of such person is not adverse to that of the minor. So where the interest is not adverse, okay, and that he is not, in the case of an next friend, a defendant, or in the case of a guardian ad litem, a plaintiff. Yeah. So there must not be conflict of interest. So the idea here is no conflict of interest should be present. Where a minor has a guardian appointed or declared by competent authority, no person other than such guardian shall act as the next friend of the minor or be appointed his guardian ad litem. So where a minor has a guardian appointed or declared by competent authority, no person other than such guardian shall act. Unless the court considers for reasons regard that it is for the minor's welfare that the person should be changed, okay? No person shall without his consent be appointed. So it's not like it's not a must. The person has to consent to acting on behalf of the minor, okay? Where there is no other person fit and willing to act as guardian ad litem, the court may appoint any of its officers to be such guardian. So the court can also appoint any of its officers and may direct that the cost to be incurred by such officer in the performance of his duties as such guardian shall be borne either by the parties or by one or more of the parties to the suit. Okay. Mm-hmm. Okay. Yeah. So the person appointed by the court is paid, okay? Is paid to act in that capacity. Okay. So the name that will come in any application, okay, the court to the court made on behalf of the minor will be made by the next friend or guardian ad litem, okay? So what happens when a minor is not represented in this application? Sorry, is not represented by the next friend or guardian ad litem in these applications. So where the advocate proceeds to just file applications in the name of the minor without the guardian ad litem or the next friend, then the advocate will bear the costs, okay, of such application. So the advocate bears the responsibility, okay? So it's very important to be aware of the minority of the person you're representing. So where the guardian acts for the minor, okay, who is suing or being sued, okay, the receipt, any property, any money they receive on behalf of the minor cannot be done except with leave of the court. So he will not receive any out of court settlement that you can do, or any settlement they have done, they have agreed upon, okay, to compromise before the order is made, or to get the award of the judgment or decree. That cannot be done except with the leave of the court. Now, agreement or compromise of suit on behalf of minor. No next friend or guardian ad litem shall, without the leave of the court expressly recorded in the proceedings, enter into any agreement or compromise. So that is very important. Where there's a person, a guardian or next friend acting on behalf of a minor, if you are negotiating with the other party, okay, to settle out of court, you can't just take your own initiative and do that. You have to ask for the leave of the court, and that settlement or that leave is going to be part of the record of that suit, okay, in that suit. Any agreement or compromise entered into without the court's leave shall be voidable against all parties other than the minor, okay. Retirement of next friend. Unless otherwise ordered by the court, a next friend shall not retire without first procuring a fit person to be put in his place. So a next friend cannot retire without first procuring a fit person to be put in his place and giving security for the costs already incurred. Okay. The application for the appointment of a new next friend shall be supported by an affidavit showing the fitness of the person proposed, and also that he has no interest adverse to that of the minor. Yeah, so where a guardian retires, another one can be appointed, okay? Or where, sorry, not a guardian, where the next friend retires, he will not retire without procuring another person who can replace him, okay? And give security for the costs that have already been incurred. The application for the appointment of a new next one shall be supported by an affidavit showing the fitness of the person proposed, okay, and also that he has no interest adverse to that of the minor. So the application is known plus is a supporting affidavit, but really this application, I just don't know. Now, removal of next friend, where the interest of the next friend of a minor is adverse to that of the minor, or where he is so connected with a defendant whose interest is adverse to that of the minor as to make it unlikely that the minor's interest will be properly protected by him, or where he does not do his duty, or during the pendency of the suit ceases to reside within Kenya, or for any sufficient cause, okay, application may be made on behalf of the minor or by a defendant for his removal. And the court, if satisfied, okay, may order the next one to be removed. So yeah, it's all very it's all like where someone is not available, okay, where is not competent, they have to be removed. Now, stay of proceedings. So proceedings will be stayed to in that time as a new person is being appointed. Okay. Now, what happens in the case of a guardian ad litem, where he wants to retire or does not do his duty, or where other sufficient ground is made to appear, the court may permit such guardian to retire or may remove him and may make such orders to costs. Where the guardian retires, dies, or is removed by the court during the pendency of the suit, the court shall appoint a new one in his place. Procedure where minor attains majority. A minor plaintiff or a minor not a party to a suit on whose behalf an application is pending shall, on attaining majority, elect whether he will proceed with the suit or application. Where he elects to proceed with the suit or application, he shall apply for an order discharging the next friend and for leave to proceed in his own name. Yeah. So he will do it in his own name, okay, if he wishes so, and apply for an order to discharge the next friend. So the title of the suit or application shall be corrected to read AB let a minor by CD his next friend, but now having attained majority. What? Okay, where he elects to abandon the suit or application, he shall, if a sole plaintiff or sole applicant, apply for an order to dismiss the suit or application on repayment of the cost incurred by the defendant. Okay, so any application under this rule may be made ex parte by chamber summons, but no order discharging a next friend and permitting a minor plaintiff to proceed in his own name shall be made without notice to the next friend. So where the minor wishes to represent himself after attaining the age of majority, that will be the application is made by ex parte chamber summons. Okay. Let me just note this down. Okay. Okay, so that is that. We have made it. Oops, sorry. Moving on. Now, so this order is basically explaining everything you would need to know. Now, where a minor complainant attaining majority desires to repudiate suit, okay? Where a minor complains for not attaining majority desires to repudiate the suit, he shall apply to have his name struck out as complainant, and the court, if it finds that he is not a necessary party, shall dismiss him from the suit on such terms as to cause. Notice of application shall be served on the next friend, on any complainant and on the defendant. The cost of all parties to such application and of all or any proceedings theretofore had in the suit shall be paid by such persons as the court directs. Where the applicant is a necessary party to the suit, the court may direct him to be made a defendant. Now, unreasonable or improper suit. A minor attaining majority may, if a sole plaintiff apply that a suit instituted in his name by an expert, be dismissed on the ground that it was unreasonable or improper. Notice of the application shall be served on all parties concerned, and the court, upon being satisfied of such unreasonableness, may grant the application and order the next friend to pay the cost of all parties in respect of the application and of anything done in the suit. Okay, so application of rules to persons of sound mind and sound mind. The provisions contained in rules 1 to 14, so far as they are applicable, shall extend to persons adjudged to be of unsound mind and to persons who though not so adjudged are found by the court on inquiry by reason of unsoundness of mind or mental infirmity to be incapable of protecting their interests when suing or being sued. So it's the same with children as it is with people of unsound mind. That is very, very clear. Now we move on. Now, joiner of parties. Joiner is permissible in instances where either the defendant is not the only one liable, plaintiff is not the only one aggrieved, where there are separate suits filed and common questions of fact or law might arise in those suits. The rights of the parties to sue arise out of the same transaction or series of transactions. So where we have multiple defendants or multiple plaintiffs, they will be joinder of parties, okay, as long as there are common questions of fact or law and the rights of the parties arise out of the same transaction or series of transactions. Moving on, how to approach the court. Originating an action. Legal proceedings are commenced when a plaintiff makes a complaint or demand before a court in due form. So this is now the pleadings part, okay? Pleadings, where we'll discuss pleadings, types of pleadings. Oh, excuse me, please. I must be tired or something. But we can't afford to be tired. Now, originating. So how do we approach the court? Originating an action. Legal proceedings are commenced when a plaintiff makes a complaint or demand before a court in due form. So we have where originating an action, where the plaintiff takes the initiative to complain. Every pleading in civil proceedings shall contain information as to information as to the circumstances in which it is alleged that the liability has arisen, that is order 2 rule 1. Order 2 rule 1. Pleadings generally. Every pleading in civil proceedings, including proceedings against the government, shall contain information as to circumstances. All right, so where there's no further information, the defendant can request, for further information. Where such a notice has been given, the time for appearance shall expire 4 days after the defendant has notified the plaintiff in writing that he needs more information. Another formal requirement: every pleading shall be divided into paragraphs numbered consecutively. Each allegation being so far as appropriate contained in a separate paragraphs, and facts must be pleaded and not evidence. All these things, all of them. So now we have types of pleadings here. So legal proceedings can be commenced by way of a plaint, by way of originating summons, by way of notice of motion. There was one here, there's under pleadings, we had all these things. Okay, so we have statements of claim, statements of defense, all these are pleadings. Claim is by the plaintiff, defense is by the defendant, plaints, demand letters, those are pleadings, counterclaims, originating summons, chamber summons. This they say it's not a pleading, yeah. Petitions, notice of motion, all these are pleadings I have mentioned, yeah. Now moving on. Chamber summons. A chamber summons is not a pleading, they said. Under this case, Jacinta Mwiruri versus Jane Mwangi and another. Okay. So we have a plaint. So the plaint is made up of you start with the title Republic of Kenya in the court that you are going to, okay. Civil suit number this of this year, ABC, plaintiff versus XYZ, defendant. Then you indicate the plaint. You say plaint, underline. You indicate the track, whether it's fast track or, okay, this track system. Let me just say what it's all about. Track. Let me just look. I like to know all these things, okay? Everything that I think I don't know, it's best if we just go into it now. Okay, I don't see where I can read on track allocation. Track. Hmm. Yeah, I don't see track. I don't know why. Yeah, I think I remember it should be in filing. Track should be in filing. Just filing, yeah. It has to be. Come on. Come on. So this page, let me just, now it's just to guess and guess, and I don't see anywhere, like serious. I wish I would know how this allocation is done. Track allocation. Okay. Hmm. Okay. Okay, God is good. It's just here. So case track system, how do you allocate track to a case? Order 3 rule 1, the claim shall indicate at the heading the choice of track, namely small claims. Small claims refers to a simple claim involving not more than two parties and whose monetary value does not exceed 49,000 shillings. 49,999 shillings. A fast track refers to a case with undisputed facts and legal issues. relatively few parties and would likely be concluded within 180 days after the pretrial directions under Order 11. So let me just look at these orders, please, because I want to be sure. I want to understand. I want to be sure. Okay, so it's under Order 3, Rule 1. Okay, it says that a small claim will refer to a simple claim whose monetary value does not exceed 200,000 shillings. Okay, fast track refers to a case with undisputed facts and legal issues, relatively few parties, and would likely be concluded within 180 days after the pre-trial directions under Order 11. Multi-track refers to a case with complex facts and legal issues or several parties and which would likely be concluded within 240 days. From the date of the pre-trial directions. So what do you do when you are choosing a case track? The plaintiff shall have regard to all relevant considerations, including the complexity of the issues of fact, law, or evidence. Okay. The financial value of the claim, the likely expense to the parties, the importance of issues of law or fact to the public, the nature of the remedy sought, okay, the number of parties or prospective parties, and the time required for pre-trial disclosures and for preparation for trial or hearing. So the nature of the remedy sought, the number of parties or prospective parties, yeah, the value of the claim, as well as the complexity of the issue. So where you are dealing with complex issues of fact or law or evidence and several parties, this is multi-track, okay? And it will take longer than the fast track or the small claim to be determined. Okay, so that was under Order 3, Order 3. But I remember there's the small claims court nowadays, which handles all matters that that have a value of up to 1 million shillings. So you wouldn't go to a court with a small claims, an ordinary court. You would go to the small claims court for all your matters that do not exceed 1 million shillings. Yeah. So I think now the cases that we would like look at mostly will be fast track, where you refer to a case with undisputed facts, relatively few parties, and likely be concluded within, let's say, within 180 days. That is 3 months, 6 months, yeah. So within 6 months, it's the fast track. Okay. Multi-track is a case that would go as far as whatever 240 days, so 6 months. That is 8 months, yeah. So it would go to about 8 months multi-track. Okay. Now here we have a sample plaint that is, I will read it out to you. Republic of Kenya in the High Court of Kenya at Nairobi Civil Suit number 33 of 2015. ABC, the plaintiff versus XYZ, the defendant. Plaint fast track. So here it's fast track, meaning that it will be concluded very quickly in about 6 months time. It has also no disputed facts or legal issues and has few parties. So the plaintiff is a male adult Kenyan of sound mind residing and working for gain in Nairobi. So when we talk of plaintiff, the first paragraph, that is paragraph 1, describes the plaintiff. The second paragraph 2 describes the defendant and his address for service, as well as then you move on from that to the claim. The third paragraph, which discloses the claim and the particulars of that cause of action. If it's negligence, you describe. So you move on like that, and then you date your plaint, and yeah, you write the service. So So remember, the document heading is incomplete without the track system being addressed. So it's very important to allocate your track, okay? The description of the parties is the plaintiff is an individual domiciled and working for gain in Nairobi within the Republic of Kenya. Her address for the purpose of this suit shall be care of, you write the advocates. Then the defendant is at all times herein mentioned a corporation duly organized and existing under the laws of Kenya with its offices and principal place of business in Nairobi within the Republic of Kenya. The address of service for the purpose of this suit shall be through the plaintiff's advocate's office. Okay. At all times herein mentioned, the defendant was operating a flight service. Now, then that is after the description of the parties, you move on to the facts. On or about June 8th, 2014, the plaintiff traveled from Nairobi to Eldoret on board the defendant's airline, and upon a ticket purchased and received by her from their offices on 6th floor, Conspicuous Emporium, Restoration Avenue, Nairobi. Upon boarding the aircraft, the defendant received, took charge, and placed her briefcase containing clothes, rare reading materials, and shareholder certificates in the luggage chamber. Upon arrival and disembarkment at Eldoret, the plaintiff did not receive her luggage from the custody of the defendant as intended. Oh, so this is a question about someone who boarded a bus to travel to Eldoret, and then upon arriving there, their bag was missing. Okay. uh, oh, this is not a bus, it's an air it's a plane. Okay. uh, yeah, so this airline is being sued. So this is very nice, this is very very nice. Then we have a reply to the plaint. uh, Oh, so another important thing is when you are drafting a plaint, you do not, when you are trying to disclose the cause of action or the claim, um, you do not go straight to say the defendant was negligent, in not securing the bag. That would be pleading the law. Okay, let the judge or the court decide whether he was negligent or not based on the omissions or the actions the defendant has done. So simply just use the wording correctly. This is very important here. Mm, you could use thing words like the defendant failed to secure the bag, the defendant uh, did not ensure safe conveyance of the plaintiff's bag. Okay. Mm. So don't go contract breach, negligence. No, that is for the court to determine the existence of negligence. Just state the actions and the omissions which led to that, inference, because you would be inferring, and your work is not to infer, it's just to state the facts. Okay. Okay. Now, that is that, and it's very important. We have seen how these questions can be raised. Let me take a break from here as I go refresh, and then I will come back.